What to do when there is a breach of a real estate contract by buyer. Selling a home can be troubling enough, but it can be even more worrisome when there is a real estate breach of contract. Understanding and being familiar with real estate contract law can be frustrating. This video will focus on the following points for a breach of contract case. What is a real estate breach of contract? What are some ways real estate contracts are breached? What happens to earnest money deposits when buyer backs out? What are the real estate breach of contract remedies? How to sue a buyer for breach of contract? What can a real estate attorney do to help? What is the breach of contract in real estate or real estate breach of contract definition? If one party to the contract does not fulfill their obligations per the contract, it is considered a breach of the real estate contract. What are some ways that a breach of real estate contract can occur? A buyer may breach a real estate contract in a variety of ways. The most common ways are by failing to obtain adequate financing before the closing date. Most real estate contracts are predicated on the buyer's ability to obtain financing. When buyer is unable to sell their current home before closing on the new home and therefore cannot go through with the purchase. When a buyer breaches by failing to pay on time. When a buyer breaches by failing to deliver the deed of property in the correct way. What happens to the earnest money deposit when a buyer backs out and buyer breaches the real estate contract? When you sign a contract to purchase property, it is typically accompanied by an earnest money deposit. The amount of the deposit varies according to each transaction, but is generally 5% to 10% of the purchase price. Paying an earnest money deposit is a way for the buyer to show the seller that the buyer seriously intends to purchase the property in good faith, because if the deal doesn't go through, the buyer may not get their money back based on the terms of the contract. If the seller backs out of the contract per the terms of the purchase agreement and properly voids the contract, the buyer typically gets their earnest money back. However, where the buyer, as the breaching party, backs out and there is a default by the buyer, whomever gets the earnest money depends on whether the buyer has a valid reason for backing out of the deal. For example, a buyer would likely get their money back if they were denied for a mortgage and properly provided such denial notice to seller's attorney within the mortgage contingency period. On the other hand, the seller would likely keep the deposit if the buyer simply changed their mind. If both parties believe they are entitled to the earnest money deposit due to a contract breach, the matter can be taken to court and the seller can engage in litigation for breach of a real estate contract. The deposit cannot be taken out of a seller's attorney's escrow account until a judge rules on it. What are real estate breach of contract remedies? In New York, most purchase contracts state that the damages due to the seller for a buyer's breach of contract are limited to the amount of the contract deposit. It's important to note that as the seller, if you choose to file a lawsuit, the buyer may file a lis pendens. This notice shows that your property is involved in a lawsuit and you won't be able to sell your property during this time. Potential buyers are not likely to make offers, and most won't even look at your property, knowing that it could be tied up in the courts for some time. How to sue buyer for breach of contract or for breach of real estate contract by buyer. Legal claims for breach of contract can be resolved through arbitration, mediation, or small claims court. In binding arbitration, the arbitrator's decision is final. If mediation is chosen, the mediator does not decide the case, but merely helps the two parties reach a decision. Filing a small claims court action generally involves sums below $5,000. These methods cost less and take less time to achieve results than litigating the matter in court. A breach of a real estate contract usually provides for liquidated damages, which are a specific amount of money awarded if there is a breach. As mentioned above, liquidated damages can be limited to the amount of the earnest money deposit. If a breach of contract lawsuit is filed, a complaint must be drafted stating how the breach occurred and the damages sought. It is recommended that you hire a real estate lawyer to help you resolve a real estate contract breach. A lawyer can be helpful by writing a letter or making a phone call on your behalf or representing you in a court action. What can a real estate attorney do to help? As a seller in which there is a breach of real estate contract by a buyer, a real estate attorney or law firm is crucial in evaluating your options and the best course of action against the buyer. At law offices of Uri Mashis, we are experienced in such real estate matters and real estate contract law. We represent sellers and buyers in the greater New York City area, including all its boroughs, including Manhattan, Brooklyn, Queens, the Bronx, and Staten Island, as well as northern New Jersey, Long Island, and upstate New York. We can also provide a consultation if you are the breaching buyer. If a buyer breached their real estate contract and you wish to discuss your case, we will provide a free consultation.